Let me, Your Lordships. Well, Lords, in this case, the validity of certain provisions of the rules framed by the state government under the for appointment of state teachers appointment is concerned, that is clearly against the provisions contained in the right of children to free and compulsory education act framed in 2009 and the further subsequent notifications and guidelines issued by the central government and in CT in that regard. So I'll begin and take your lordships, my lords, with the provisions of the right of children to free compulsory education, which is for convenience of your lordships, it is already on record also. Or if your lordships will kindly see the book concerned. The RTE Act, my lords, in this, my lords, three provisions I'll first show, my lords. Section.
My lords, I have an objection. I'm not, my lord, up till now I am not aware which rule he is challenging.
It is
Rule
very
5.
much there.
Rule 5.
Rule
No,
5,
Rule
yes.
5 of, there is 12 rule, then there is 20 rule. In the writ application,
He has filed writ in 20, therefore 20 rule.
no, my lord, I will indicate. In the writ application, he challenged 12 rule.
Amendment is there. Perhaps my friend is not aware that has already been allowed. That the amended rule of 2020.
I am aware, therefore I am saying that I am unaware as to which rule you are challenging. Because, my lord, appointment has been made under 2012 rule. After coming into force of 20 rule, he filed an application seeking amendment in the writ application, and he has challenged 20 rule. He has given up his challenge to 12 rule. All appointments have been done under 12 rule.
So now those possessing CTET qualification have been allowed, scope enlarged.
Yes, and more than
So
50,000 appointments has
choice,
already
wider
been done.
competition.
Pardon, my lord.
Wider choice for them, wider competition for you.
My lord, up till now, more than 50,000 appointments have taken place. They have joined.
CTET candidates cannot be allowed on this score, my lords. There are two decisions also of one of the Punjab and Haryana High Court division bench decision and Honorable Rajasthan High Court's decision, which I have already brought on record. They have also said that CTET candidates cannot be permitted in a state level teachers appointment eligibility test where it is being conducted. In our state, it is being conducted. And if they say that we have already issued appointment, that will be in teeth of your lordship's order dated 1st of February 2022, when your lordships had already indicated, it is thus directed that the selection, if made in the meanwhile, shall be subject to the decision of the writ application. They ought not to have first issued the appointment, even if they say that it has, that will be subject to which your lordships have already indicated.
Now, my lord, the writ application has become leisure interest litigation.
Anyway, if he is now stopping, then I will start, my lords.
Which have been allowed.
Your selected candidates.
No, CTET candidates. At that time when he had
all three of you
my lord.
give us a 2-3 page synopsis.
My lords, I had, if it is there,
No, we don't need it today.
Oh,
We'll keep it next week.
My lords.
We'll keep it. We'll have to spend some time on it.
Lordships.
So synopsis should not be more than 3 pages,
Lordships.
so that we can quickly take a decision. We'll keep it at 2:15.
2:15.
Today?
Not today.
Next week.
Next week.
Thursday. This Thursday or?
So on joint request, adjourn to next week.
But you give the 3-page synopsis along with the judgment which are being relied and all the provisions, all the act.
By tomorrow or day after I'll possibly.
Punjab judgment is in your favor?
My lords, two
Punjab.
judgments one of Honorable Punjab and Haryana High Court Division Bench and one Rajasthan, which is already on record. I'll give the pages and paragraphs.
Rajasthan is not necessary. Neither of us is from Rajasthan.
Lordships. अरे सर आपको नहीं देंगे